Thank you all for coming. My name is Kathleen O'Driscoll, and this is Kate Andres, and we are two of the 5 members of Miss Magna Carta. We wanted to first say a thank you to the Center for Constitutional Studies for sponsoring this event. Dr. Carolyn Harris is a historian, author, and royal commentator based in Toronto. She currently teaches history at the University of Toronto School of Continuing Studies. She's the author of 2 books. The first is Magna Carta and Its Gifts to Canada, Democracy, Law, and Human Rights, as well as Queenship and Revolution in Early Modern Europe, Henrietta Maria and Marie Antoinette. Carolyn completed her PhD in history at Queen's College at Kingston in May 2012. She completed 6 months of her doctorate at Birkbeck College, University of London, in 2009 as a visiting overseas research student.
Carolyn is an expert in the history of European monarchy and has been interviewed by numerous media outlets, including CTV News Channel, CNN, BBC Radio 5, CBC Radio, Radio Canada International, TVO's The Agenda, the Toronto Star, the National Post, and the Globe and Mail. Yes, quite a few. Her writing concerning the historical context for issues facing the British and Canadian monarchies today has appeared in various print and news magazines as well. About an equally long list to the different radio shows she's appeared on. Carolyn is also a prolific guest lecturer both on land and at sea. She has delivered talks on the monarchy for numerous museums, libraries, universities, and educational organizations. She also contributes to cruise ship enrichment programs. So if you're planning a vacation in the future, I think I know where my next vacation will be. So with that, we're going to turn things over to Carolyn Harris. So welcome.
Thank you very much for coming here to discuss Magna Carta on its 800th anniversary. There are very few medieval charters that we are still talking about 800 years later. It's unlikely I would have been able to fill a lecture hall with a talk on the Assizes of Clarendon that preceded Magna Carta, even though it's a very significant document. We see the development from trial by ordeal to an evidence-based justice system. So significant as well, but that document and other documents of its kind haven't had the resonance that Magna Carta has had, because Magna Carta has been interpreted and reinterpreted by generations of political and legal thinkers, writers and artists as well, and has gone from being an agreement between King John and his rebel barons and clergy to a much more timeless symbol today of democracy, law, and human rights. The document is issued and reissued over the course of the 13th century, and there's a version of Magna Carta from 1300, the reign of King John's grandson, Edward I, that's on display at the Alberta legislature right now as part of the touring Magna Carta Canada exhibition. So over the next hour, I'm going to go through about 8 centuries of history from King John's reign to the present day, looking at Magna Carta's impact and how it evolved from a document that neither King John nor his barons thought would outlast the turbulent political circumstances of 1215. And then the document's provisions expand to more and more groups within the English population. The Magna Carta has a period of obscurity and then is reborn in the 17th century and assumes a wider significance, first in the Atlantic world and then in a more global context. So 8 centuries of Magna Carta and how this document has been interpreted over time. So we'll begin in the reign of King John, who succeeded his elder brother, Richard the Lionheart, in 1199, and had a disastrous reign until 1216. King John has been almost universally vilified both in history and in popular culture. Those of you who've seen any of the Robin Hood films will remember him as the villainous Prince John. Even Disney's Robin Hood says he was too late to be known as John the First. He's soon to be known as John the Worst, the phony King of England. And this is in contrast to many other kings who had bad reputations, but there's a revisionist view on them. Richard III has an entire society that tries to rehabilitate him, but there's no King John society. There have been no efforts to rehabilitate King John, and this is because when we look at his reign, the fact that he managed to violate so many of the unspoken customs that determine the role of a medieval monarch, that his most prominent subjects were determined to unseat him, for the conflict with his subjects to have reached that level, demonstrates that his reign was unsuccessful. He alienated key groups that were essential for a medieval monarch to remain in power. There's never been a time that a monarch could simply do whatever he wanted. John's great-grandfather, Henry I, had issued a coronation charter in 1100, stating he would respect the freedom of the church, the inheritance rights of the nobility. Noble widows would not be forced to remarry. The barons could settle legal disputes amongst themselves. And this had come to be seen as binding law and custom, that future monarchs were expected to promise and to uphold what Henry I had promised. But John manages to alienate all these key groups that he has to keep on side to remain in power. He's excommunicated by the church in a conflict with Pope Innocent III over the appointment of the Archbishop of Canterbury. The Pope favored Stephen Langton, who King John did not favor in this role. He thought that Langton was far too closely connected to the court of King Philip II of France. Langton had been educated at the Sorbonne, had spent extensive time at the French court, and John wanted to reward one of his own supporters with the position of Archbishop of Canterbury. So John is excommunicated. England's placed under interdict for a time where religious sacraments cannot be performed, and that affects people of all social backgrounds. John gets a reputation for arbitrary rule in his treatment of his barons, that imposing harsh punishments for comparatively light offenses. For example, his treatment of the Brose family, who controlled much of the land along the Welsh border. William de Brose had once been one of John's favorites, but he owed a sum of money to the monarch, and so John insisted that he send his son to the royal court as a hostage. And William de Brose's wife, Maud, publicly said, perhaps unwisely, that she would not give up her son to a king who'd murdered his own nephew. And John's nephew, Arthur, and rival for the throne, had indeed disappeared in John's custody, and there was all sorts of speculation about how the young man had died. John was outraged that he was being accused in this manner. The Brose family were run off their lands. William manages to flee to France, disguised as a beggar, but Maud and her son were imprisoned in a castle dungeon and starved to death. So for the barons seeing these kinds of events unfold, there's a sense that this could happen to any of them, losing their lands and their families at the king's whim, and that something had to be done. In addition to his misrule, John also gets a reputation for personal villainy. Other kings that had mistresses, John tended to target the wives and daughters of his barons, so he made some very powerful enemies. All of this might have been forgiven if John had been able to carry out the primary duty of a medieval monarch, which was to effectively lead the troops into battle. But he suffers a series of military defeats by Philip II of France. He loses that vast Anglo-French empire that had been controlled by his parents, Henry II and Eleanor of Aquitaine. Anjou, Normandy, parts of Aquitaine fall to the French. And we remember John does not have a standing army. He relies on calling up his wealthy barons to call up their knights to fight for him. And after a disastrous defeat at the Battle of Bouvines in 1215, his barons and a key group of rebel barons refuse to keep fighting for the king unless he accepts limits on his power. In past reigns, discontented nobles had simply found an alternate member of the royal family to support their claim for the throne, but John John having arranged for the disappearance of his nephew Arthur, and him having been a youngest son, and his own children being quite young at this time, there isn't a clear alternate claimant. So John instead becomes the first monarch to accept limits on his power imposed by his subjects, rather than issuing these voluntary coronation charters as previous kings have done. So we see up on the slide, the Barnwell Chronicle just describes just how unpopular John had become by 1215, the year of Magna Carta and the year before his death. He was generous and liberal to aliens, but he plundered his own people. He ignored those who were rightfully his men and placed his trust in strangers. Before his end, his people deserted him, and at his end, few mourned him. And this is not an epitaph that a medieval monarch wants to have. So John is forced to meet with his barons. One of the rebel barons controlled Baynard's castle, the city of London. So John had lost his capital. His barons will not fight for him any longer. So he's obliged to meet with them at Runnymede Meadow, June 15th, 1215. Runnymede Meadow's neutral ground between Windsor Castle, which had been a royal residence since 1066 and still is today, and the city of London, which had fallen to the rebel barons. And John has these terms imposed on him, drawn up by Archbishop Stephen Langton, who'd finally been allowed to assume the role of Archbishop of Canterbury. It's believed that Langton brought together the various grievances of the barons, the clergy, the London merchants, John's two discontented sons-in-law, Llewellyn the Great, Prince of Wales, and King Alexander of Scotland. All of these different groups and interests who all opposed King John's rule. The beginning of the Magna Carta is very similar to Henry I's coronation charter. We have freedom for the church, inheritance rights for the nobility. Noble widows will not be forced into remarriage. But then at the heart of the document, we have clauses 39 and 40 that when the document's reissued later in the 13th century will be combined as clause 29 about the administration of justice. And these are the clauses that have had a profound impact on the development of the common law system. So number 39, no free man shall be seized or imprisoned or stripped of his rights or possessions, or outlawed or exiled or deprived of his standing in any way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. To no one will we sell, to no one deny or delay right or justice. So what had happened to the Brose family was supposed to never happen again, that there would be checks and balances on the king's power. And these clauses in subsequent centuries would be interpreted as making clear that not even the king was above the established laws and customs of the land. And so this has had a profound resonance. See, the image on the slide depicts the doors of the U.S. Supreme Court that show Magna Carta being imposed on King John. As you can imagine, no sooner had King John affixed his seal to the document. He doesn't sign Magna Carta, he seals it. That's much harder to forge than a signature. And whereas John was quite well educated, as a youngest son, he'd been educated at Fontevraud Abbey and perhaps had considered a church career before the deaths of his elder brothers. Not all previous kings have been literate, so a royal seal was also a way of upholding a document for kings who may not have known how to write. But in John's case, no sooner has he affixed the seal to the document than he's already thinking of how he can return to life before Magna Carta, how he can put this document aside. After years of conflict with the papacy, he reconciles with Pope Innocent III. He will allow the papacy to make ecclesiastical appointments in England in exchange for being released from his oath to uphold Magna Carta. And so John puts aside Magna Carta. The First Barons' War breaks out between John and his rebel barons. The siege of Rochester Castle ensues. And the barons return to the tried and true methods of unseating a medieval king, find a rival claimant. They found a French prince who was married to John's niece, Blanche of Castile, and invited the young Dauphin Louis, the future Louis VIII of France, to invade. And and it seemed as though Magna Carta was simply going to become a failed medieval peace treaty. But John dies in 1216, reputedly of a surfeit of peaches and cider, most likely of dysentery. There were even rumors he'd been poisoned because he's so unpopular by this time. And his heir is a 9-year-old boy, the future Henry III. And in the past in English history, the rights of child heirs to the throne had often been swept aside. John's nephew Arthur, for instance, even though this was the son of his elder brother Geoffrey, an adult man was considered preferable by many, to a young person who didn't have the same military experience. So there hadn't been a child king of England since Ethelred the Unready in Anglo-Saxon times. And as you can tell from that nickname, his reign did not go well. The Vikings invaded, Sweyn Forkbeard, and then Canute came to the throne, and Ethelred became another one of those monarchs with a terrible reputation for misrule. But in Henry III's case, the rebel baron saw an opportunity. At only 9 years old, he would need years of adult members of the nobility ruling on his behalf. And this would be an opportunity to reissue Magna Carta, reissue another charter, the Charter of the Forest, which reformed forest law at this time, and a version of the Charter of the Forest is also on display at the legislature. So Henry III is crowned king at the age of 9. The French prince is paid to go home, and a council of barons served as regents for Henry III as he grew up. The Charter of the Forest addressed the issues within forest law. King John had treated the royal forests as a source of revenue, imposing fines on people who gathered firewood or wanted to pasture their sheep or dig ditches to keep wild animals out of their crops. And this is the medieval warm period. The population's expanding. There's demand for more and more forest resources. And so the Charter of the Forest dictated that use of forest resources was to be decided by communities rather than at the king's whim. And the Charter of the Forest also gets rid of some of the draconian punishments for hunting the king's deer, losing life or limb that had existed before that. And the Charter of the Forest becomes one of the longest standing pieces of legislation in British history. It is not superseded until the Forest and Wild Creatures Act of 1971 that finally makes clear that the Queen does not own the big game in the United Kingdom. So there are parts of the Charter of the Forest that remain on the statute books even longer than certain parts of Magna Carta that are repealed in the 19th century. So when Henry III comes of age, he agrees to reissue Magna Carta and the Charter of the Forest in exchange for some new taxes, and it seems as though the conflict between king and barons will come to an end. But Henry III, like King John, comes into conflict with his nobles and members of the clergy as well. Henry III doesn't have that reputation for personal villainy that King John had. He had a very happy marriage to his queen, Eleanor of Provence, was a loving father to his 5 children, including one who had special needs. There's accounts of him arranging for her to have pets as she was deaf and had difficulty engaging with other children. Henry III was also very interested in building and Gothic architecture, and he commissioned the modern Westminster Abbey that stands today, and improvements to the Tower of London and Windsor Castle and the Great Hall at Winchester Castle. So even if you haven't heard of Henry III, if you visited London or Winchester, chances are you've seen evidence of his building projects. So not the villain in a personal sense that King John was, but he tended to interfere with the justice system to ensure that his own relatives were looked after in disputes with the barons. His wife's aunts, uncles, and cousins had all come over from Provence and Savoy wanting to seek their fortune in London. He also had a lot of siblings to look after. King John's queen, Isabel of Angoulême, had been only 12 when they married. So they had 5 children, and then Isabel as a widow had remarried and had another 9 children. So Henry III had a lot of half-siblings who all wanted to be looked after. And so the barons felt once again they were dealing with arbitrary rule, that the king was interfering in legal cases. And it became clear that simply reissuing Magna Carta, which had happened a number of times over Henry III's reign, was not enough. There needed to be lasting political institutions to ensure that the king accepted the will of the elite groups amongst his subjects. Opposition to Henry III coalesced around his brother-in-law, Simon de Montfort, the Earl of Leicester, and who envisioned a wider program of political reform. And he imposed on Henry III, who was no better a general than King John was, the provisions of Oxford, calling for regular parliaments to be held, from the French word parlement, meaning the law courts. There were to be these regular assemblies that would not just call upon representatives of the barons and the clergy, but county knights and the wealthy townspeople as well. Now, 90% of the population's peasantry, many of whom are serfs bound to the land, so this is by no means political representation for all, but we're seeing a slow expansion of the political class over the 13th century, and the idea of who should be consulted is expanding from there. So the provisions of Oxford are imposed on Henry III, and they state in great detail how these parliaments would work. Concerning the parliaments as to how many shall be held annually and in what manner, it should be remembered that the 24 barons have ordained that there are to be 3 parliaments a year, the first on the octave of St. Michael, the second on the morrow of Candlemas, and the third on the first day of June, that is to say, 3 weeks before the feast of St. John. To these 3 parliaments the chosen councillors of the king shall come, even if they are not summoned, in order to examine the state of the kingdom and to consider the common needs of the kingdom, and likewise of the king, and by the king's command they shall come, also at other times, whenever it is necessary. And this leads to a parliament being called in 1265. So it's not just the 800th anniversary of Magna Carta this year, but the 750th anniversary of the de Montfort Parliament, which would serve as a model for future parliamentary government. Now, if Simon de Montfort had only been dealing with Henry III, it's likely the political program would have expanded from there, and we would have seen more de Montfort model parliaments. But Henry III's grown son was a far better general than he. Henry III's son is Edward I, better known as Edward Longshanks for his great height. He was over 6 feet tall at a time when people were shorter. And on his tomb, he's described as Hammer of the Scots, as that's how he wanted to go down in history. And as he went on to become the villain of Mel Gibson's Braveheart, that is indeed how he's being remembered for his campaigns in Scotland. But long before he became king and invaded Scotland, he coalesced opposition to Simon de Montfort. There were barons who were concerned about Montfort's motives. He was married to the king's sister. His sons had royal blood. There were concerns that these parliaments, him gathering support of a broad cross-section of the population, might simply be a precursor to him trying to move the throne into his own branch of the royal family. So even those who opposed Henry III's interference in the justice system, these opponents of Henry III did not all feel as though Simon de Montfort should be the one leading this opposition. So the future Edward I is able to take advantage of opposition to de Montfort. And so the Second Barons' War breaks out, and de Montfort's defeated and killed at the Battle of Evesham in 1265. And Edward I succeeds to the throne well on the Ninth Crusade in 1272. In the past, if a claimant to the throne was outside the country at the time they succeeded, often a relative would usurp. But after what had happened to Simon de Montfort, no relative of Edward I was going to set themselves against him. So he's able to take a leisurely route back from the Ninth Crusade and is crowned in 1274 in Westminster Abbey. Edward I, as well as being a better general than John or Henry III, is also a cannier statesman in that he understands that in order to carry out his constant military campaigns. He went on the Ninth Crusade, he fights in France, he annexes Wales, he invades Scotland. In order to be constantly at war in this manner, he needed the support of his barons, which near the end of the 13th century, this support had begun to waver due to the financial and military obligations that were imposed by the king. A popular rhyme of the time goes, "The king desires to get our gold, the queen our manors fair to hold," as people saw Edward I's wife, Eleanor of Castile, was building up a medieval real estate empire of her own. So the royal couple were seen as quite acquisitive, and there were concerns that all sorts of arbitrary new taxes would be imposed, especially as the war with Scotland went on longer and longer as English troops faced first William Wallace and then Robert the Bruce. So Edward I reissues Magna Carta in 1297, trying to keep his barons on side. This is the version of Magna Carta, the parts of which remain on the statute books in the UK, and was often the version of Magna Carta that future generations would look back to. It's a more streamlined copy of the document. Clauses 39 and 40 are combined as Clause 29. Some of the clauses unique to 1215, the names of corrupt officials who were to be removed from office, for instance, are also removed. Rights for the Welsh and the Scottish are also removed. So reflecting Edward I's own interests. So we see this more streamlined documents reissued. Some of the clauses are still on the statute books in the UK, and then when Parliament's called once again in 1300, there are calls for a more vigorous reissue of the charters, affirming that Magna Carta and the Charter of the Forest will be treated as foundational documents that future kings will not be able to violate the terms of. So the Worcester Annalist describes the barons at the Parliament of 1300, stating, "When we have secure possession of our forests and liberties, often promised to us, then we will willingly give a 20th, so that the folly of the Scots may be dealt with." So no reissue of Magna Carta, no Scottish invasion. And so Edward I not only reissues the two charters, but he issues the confirmation of the charters, which states that these documents are not to be superseded by other legislation. And this would have a profound impact on how Magna Carta would be interpreted in the 17th century, that the documents would be seen as not only medieval law codes, but as being these foundational documents within England's unwritten constitution. Now, Magna Carta had stated that the rights and provisions applied to free men, the barons, the clergy, the knights, the townspeople, those few free yeoman farmers, but this excluded the vast numbers of peasantry who were bound to the land. And it would not be until the feudal system began to break down that Magna Carta would come to apply to a larger group within the population. And this takes place within the reign of Edward I's grandson, Edward III. The 14th century monarchs are easy to follow. Edwards 1, 2, and 3, one after the other. And Edward III reigned from when he was a teenager for 50 years over a period of profound social change. In the 14th century, he claimed the French throne through his mother, Isabel of France, and he challenged the French assertion that the French succession did not go through the female line. So Edward III begins the 100 Years' War, which would continue for 114 years. His successors would go on to continue to fight for this claim for the French throne. So a very long war with France begins in Edward III's reign, and during his reign, the Black Death comes to England in 1348, and this plague wiped out 30 to 50% of the population. And we can imagine today what a destabilizing impact it would have if an unknown pestilence suddenly appeared and exacted such a devastating toll of people of all social backgrounds. Edward III loses 3 of his dozen children, and the fact that royalty were struck down and peasantry were struck down and everyone in between made it seem as though the end of days was nigh. And there's a profound social impact to this. New noble families emerge, as there might have simply been a distant cousin who's the survivor to a lot of different lands. We see evidence of women in the guilds in urban areas, as there's labor shortages there. And many members of the enserved peasantry simply leave the land and go to where their labor will be best compensated. The late 14th century is known for its peasant revolts. One of the most prominent happens during the reign of Edward III's grandson, Richard II. Edward III at first attempts to reinforce the old social hierarchy. He tries to impose a maximum wage, which is ineffective. He tries to impose limits on the mobility of the serfs. This is also ineffective. And finally, Edward III and his parliaments are forced to grapple with the fact that society has changed and that the old strict social hierarchy, the old feudal system, is never going to be the same again. So over the course of his reign, Edward III issues the 6 statutes, and it expands the provisions of Magna Carta from free men to men of all backgrounds. Item that no man of what estate or condition that he be shall be put out of land or tenement, nor taken, nor imprisoned, nor disinherited, nor put to death, without being brought in answer by due process of the law. For the first time, we're seeing the words due process, which have been implied to some degree in Magna Carta, are now being explicitly stated, and it's men of all backgrounds who are going to be covered by Magna Carta's provisions, responding to the rapidly expanding population of free men as the feudal system gradually breaks down in the late Middle Ages. Now, we've been talking a lot about men, free men, men of any estate or condition that they may be. There were clauses in the 1215 Magna Carta that applied to women, but it was a very small group of women. Noble widows would not be forced into remarriage. And this serves as a precedent for future examples of women's rights, but at the time, it would have been viewed as upholding the rights of the noble class. Barons and knights feared if they fell in battle or to disease, their wives might be forced to remarry people who the king wanted to reward with their lands, and a second husband or the monarch might squander the inheritance before the children of the first marriage had grown up to inherit. So these rights for noble widows in the original Magna Carta also reflected the interests of the entire noble class. But whether or not the provisions about justice, the right to due process, being brought to trial that were in Magna Carta and the 6 statutes, whether these provisions applied to women was not made explicitly clear until 1441 in a very high-profile witchcraft case involving King Henry VI's aunt, Eleanor Cobham, the Duchess of Gloucester. This was the case that gripped London in the mid-15th century, as witchcraft cases normally involved marginal women, the elderly peasant women or widows who sold herbs in order to make ends meet, or were otherwise considered a burden on the parish. It's very rare for someone this prominent and this well connected to be accused of witchcraft. There have been all sorts of unsavory rumors about Eleanor Cobham at the time of her marriage. Because she was from the landed gentry, she was not a princess, she didn't bring vast wealth and lands and connections, and it was thought Henry VI's uncle could have married better, and he had married better in a previous marriage. And then when Eleanor Cobham also it seemed was infertile as well, the fact that the marriage continued to be a success led to all sorts of speculation as to how this woman had been able to climb the social ladder in the manner that she did. They presided over quite a cultured and learned court. If you visit Oxford University, the oldest part of the Bodleian Library is the Duke Humphrey's Reading Room, named for the book collection bequeathed to Oxford by the Duke of Gloucester, Eleanor Cobham's husband, Humphrey, the Duke of Gloucester, and who was next in line to the throne after King Henry VI. But this witchcraft trial comes to the fore as Eleanor was accused of consulting with astrologers to predict the king's death. The fact that her husband was very high in the line of succession made this extremely controversial, treasonous even, and there were accounts of Eleanor Cobham also meeting with a figure named Marjorie Jourdain, the Witch of the Eye as she was known, and Eleanor Cobham would argue that she'd only met with Marjorie to require fertility potions so that she could conceive. You can see why this case became, became such a topic of public interest in mid-15th century London. So all these accusations were swirling. Eleanor is eventually taken into custody, and both she and her husband, who continued to support her, argue that this couldn't go on indefinitely, that she should be able to face the charges against her and clear her name. So the historian Nicholas Vincent, who's one of the foremost authorities on Magna Carta, has written in a recent book that as a result of the case of Lady Eleanor Cobham, who was accused of treason in 1441 but had never been brought to trial in a secular court, the 6 statutes of Edward III was remedied by extending to ladies of great estate the right of trial before the judges and the lords. And perhaps because of her exalted place within the royal family, Eleanor Cobham receives a lighter punishment than many witches did at the time. She was imprisoned for a period of time and had to do public penance, as the image above shows. Whereas the Witch of the Eye, who she consulted with, and the astrologers, who were much further down the social scale, were all sentenced to death. So this legal case involving such a high-profile member of the royal family opened up the debate as to whether Magna Carta, which had been extended to men of all backgrounds, also provided legal protections for women. And the result of the case was that it was accepted that women too were protected by Magna Carta. So Magna Carta comes out of the Middle Ages, applying to people of all social backgrounds. The printing press is invented later in the 15th century as well, which should have provided opportunities for Magna Carta to be disseminated further than ever. And yet, in the 16th century, during the Tudor dynasty, which reigns from Henry VII defeating Richard III at the Battle of Bosworth Field in 1485, all the way to the death of Elizabeth I in 1603, we see Magna Carta having a period of comparative obscurity, as the Tudor monarchs, particularly Henry VIII and his daughter Elizabeth I, put forward the image that a strong monarch was what was needed to defend England from external threats, whether it was France or Spain or the papacy, that the monarch should have more and more powers in order to defend the realm. Henry VIII had an interest in law, and he always applied a veneer of due process and legal proceedings to everything he did. 2 of his wives received trials before being beheaded, rather than simply being quietly disposed of. So Henry VIII wanted everything he did to look as though it was legal and above board, but it was made very clear what would happen if Magna Carta was used in order to oppose him. His Chancellor, Thomas More, highlighted that first provision of Magna Carta, freedom for the church, and tried to use that to argue against Henry VIII's insistence that all the prominent members of his realm accept the act of supremacy that made him head of the Church of England. And Thomas More was convicted of treason and beheaded, which made very clear that arguing Magna Carta in this case would not get him very far in Henry VIII's reign. So by the reign of Elizabeth I, Magna Carta had fallen out of popular culture. It was printed in volumes of antique statutes to be consulted by lawyers. Some of you may have those on your shelves. So the legal community knew Magna Carta quite well, but the population as a whole was not as familiar with the clauses of the document. So if you see a performance of Shakespeare's The Life and Death of King John, you'll notice there's not a single mention of Magna Carta in the entire play. The barons rebel, then you see a King John deathbed scene, you're looking at your program thinking they've missed something really important. But in Shakespeare's time, that scene at Runnymede Meadow had simply fallen out of the popular consciousness. It wasn't something that he would expect theater goers at the Globe Theatre to recognize. And for Tudor audiences, perhaps King John wasn't all that bad. His conflicts with the papacy that had been so scandalous in the 13th century, in the 16th century, when Henry VIII had become head of the Church of England and had broken with Rome, perhaps King John was simply ahead of his time, having a conflict with the papacy over appointments to the clergy. So we notice in Shakespeare's King John, John John is given speeches that sound like they could have been spoken by Henry VIII. Tell him this tale, and from the mouth of England, add thus much more, that no Italian priest shall tithe or toll in our dominions, but as we under heaven are supreme head, so under him that great supremacy. And that's how Henry VIII would have thought. It's not necessarily how John would have thought, but that's the lens through which King John and his reign are being viewed during the reigns of Henry VIII and Elizabeth I. The revival of Magna Carta takes place in the next reign, when Elizabeth I is succeeded by her Scottish cousin James VI of Scotland, who becomes James I of England. And James I, who'd written quite extensively on kingship, admired ideas of divine right monarchy that were practiced in France, the idea that he was king by divine right. And in these circumstances, for the legal community, Magna Carta assumed a new relevance. And Magna Carta has its revival due to the writings of Sir Edward Coke, who was a jurist and a member of Parliament. He also writes best-selling law textbooks, ensuring that his ideas on Magna Carta are spread to as wide an audience as possible. For Sir Edward Coke, Magna Carta wasn't just a medieval charter. It was the foundation of all English liberties. This is a foundational document. And he argued that the true significance of the document was that not even the king was above the law of the land. Coke also emphasized that Magna Carta provided freedom from arbitrary taxation. That's something the 13 colonies would find very appealing in the next century. So often what we think of as Magna Carta's significance, we're seeing it through Coke's eyes in terms of how he analyzed this document in the early 17th century. So he argues not even the king is above the law. If he'd been writing during Henry VIII's time, he probably would have lost his head, but luckily he's writing in James I's time. James is a published author. He sees himself as an intellectual. He decides to debate Coke rather than simply throw him in the tower. Coke explained how this debate went. I said that the law was a golden met wand and measure to try the causes of the subjects, and which protected his majesty in safety and peace, with which the king, James I, was greatly offended, and said that then he should be under the law, which was treason to affirm. So Coke had gotten himself into some hot water there. He does spend some time in the tower, but James ultimately moves him from the bench of the Common Pleas to the prosecution so that his legal acumen would be on behalf of the crown. So he decides to make use of Coke rather than simply to destroy him in his career, as previous monarchs might have done. And so Coke's views, through the law textbooks he wrote, through debates like this, are able to spread. And it's a time when the English-speaking world is expanding as well. So Coke becomes involved in a number of projects. He helps author the first charter of what becomes the state of Virginia. So his interpretation of Magna Carta begins to influence the development of what became the 13 colonies, beginning that process in which Magna Carta assumed a totemic status in the United States. The pinnacle of Coke's career, though, happens in the reign of James I's son, Charles I, who succeeds in 1625. Charles I, like his father, favored ideas of divine right monarchy. He was married to Henrietta Maria of France, the sister of Louis XIII. This is the era of the Three Musketeers. Charles I's closest friend is the Duke of Buckingham, who was involved in the marriage negotiations. And Charles, unlike his father, is not interested in having a legal debate about his prerogatives as king. He simply expects to do as he wishes as a monarch, impose taxes, hold prisoners without charge, and he views all of this as his royal prerogative. And so Coke, as a member of Parliament, chairs the committee that puts together the Petition of Right, which was heavily influenced by Magna Carta and designed to constrain Charles I. And the Petition of Right's quite a long document. I have a short excerpt here that explains the grievances against Charles I expressed in 1628. Nevertheless, against the tenor of Magna Carta and the 6 statutes, and other the good laws and statutes of your realm, to that end provided, divers of your subjects have of late been imprisoned without any cause showed, and when for their deliverance they were brought before your justices by your majesty's writs of habeas corpus, there to undergo and receive as the court should order, and their keepers commanded to certify the causes of their detainer, no cause was certified, but that they were detained by your majesty's special command, signified by the lords of your privy council, and yet were returned back to several prisons without being charged with anything to which they might make answer according to the law. So this is in the Petition of Right of 1628. And Charles I, like King John, accepts the terms imposed on him, and like King John, immediately wants to get out of this. He prorogues Parliament in 1629 and does not recall it until 1640. He tries to rule without Parliament, and eventually is forced to recall Parliament because he's run out of money, and it's Parliament who approves many of the new taxes, and Charles I found himself at war with his Scottish subjects in 1640, the Bishops' War, as he attempts to impose the Church of England on the Presbyterian Scots, and they do not react well to that. And so he summons Parliament wanting support for the Scottish campaign, and instead finds a broad base of sympathy in both England and Scotland between those who all felt mistreated by Charles I's arbitrary rule. So relations between Charles I and the newly called Long Parliament of 1640 quickly break down. The English Civil Wars breaks out in 1642. Between the king and Parliament. Charles I continues to try to play different sides off against each other, reinforces his image as an untrustworthy figure. So even members of Parliament who saw this war as keeping bad advisors away from the king, the Queen is impeached by the House of Commons in 1643, for instance, and there are other major figures who are, who Parliament wants removed from influence. By 1649, it's clear that to many parliamentarians that the king himself will have to go. So Charles I is apprehended, he's placed on trial in January of 1649, and he refuses to answer the charges, he refuses to enter a plea. Charles I's view is that the House of Commons is not a court that has the right to put him on trial, and if he was to be put on trial, he'd want to be judged by his peers, and he doesn't view people like Oliver Cromwell as his peers. Only other monarchs can judge a monarch like himself. His grandmother, Mary Queen of Scots, had made a very similar argument that she wanted to see Elizabeth I and answer to her directly rather than to a court accusing her of treason. So Charles I refuses to engage with the court. He's convicted of treason against his subjects and beheaded at the end of January in 1649. And although the interregnum only lasts for 11 years, Charles I's son is restored as Charles II in 1660. Charles I's death casts a very long shadow, and it's clear that his descendants cannot, or the course of the Stuart dynasty, cannot continue to reign as he did, and will have to be answerable to Parliament. Here's Charles I's two grandchildren, William III and Mary II, cousins who married each other, and they were invited to claim the throne in 1688. Charles II had at least 14 children, but none of them were with his queen, Catherine of Braganza. So he'd quite literally become the father of his people, but he had not ensured a lasting succession. So Charles II had been succeeded by his brother James II, who was a Roman Catholic, but he was the father of two Protestant daughters, the elder of whom was married to her very Protestant cousin, the Dutch Prince William of Orange. So the Protestant elite felt they simply had to wait this out. James II's reign would come to an end, he'd be succeeded by William and Mary, all would be well. But instead, James II had remarried a Catholic Italian princess, Mary of Modena, and they have a son in 1688. And rumors begin to circulate, and Mary and her sister Anne encourage these rumors that this wasn't a royal prince at all. A baby had been smuggled into the palace in a warming pan, and there's a recent documentary of Lucy Worsley that showed how big a warming pan is and how hard it would be to actually put a baby in there and smuggle it in through a very busy royal court with lots of people and servants coming and going. So there's no evidence that this actually happened, but this serves as a pretext for William and Mary to be invited to invade. James II, remembering what happened to his father, Charles I, promptly flees. He's later defeated by William at the Battle of the Boyne in Ireland. And so William and Mary are accepted as joint king and queen, but not until they accept the Bill of Rights, which serves as the origin document for the constitutional monarchy. That's the system of government in Canada, the United Kingdom, and 14 other Commonwealth realms. Parliament was getting very tired of having to treat with each individual monarch and renegotiate that relationship. So they wanted there to be a lasting system, a lasting system in which the monarchy acted on the advice of Parliament. So I have up here an excerpt from the Bill of Rights that makes very clear what the King and Queen could and could not do. And thereupon the said Lords Spiritual and Temporal and Commons, pursuant to their respective letters and elections, being now assembled in a full and free representative of this nation, taking into their most serious consideration the best means for attaining the ends aforesaid, do in the first place, as their ancestors in like case have usually done, for vindicating and asserting their ancient rights and liberties, declare that the pretended power of suspending the laws and the execution of laws by regal authority without the consent of Parliament is illegal. That the pretended power of dispensing with laws and the execution of laws by regal authority, as it has been assumed or exercised of late, is illegal. William accepts the Bill of Rights on behalf of himself and his wife, and then they are crowned William III and Mary II, and future monarchs are expected to adhere to this. The origins of the civil list also come out of this document. So a lot of aspects of how the modern constitutional monarchy would be put together come out of this document. We see the emergence of the prime minister's role in the next. In the 18th century, when the Hanover dynasty came to the throne, as George I's English was a little shaky, and various members of his court had been involved in the South Sea bubble economic crisis. So we see Sir Robert Walpole assuming that role of prime minister that would continue from that point forward. So that's what's happening in the UK. Meanwhile, in the 13 colonies, Sir Edward Coke's writings had a profound impact on political and legal ideas there. And Magna Carta is treated in quite a literal sense, as Coke intended for it to be, as this foundation of English liberties. And as immigrants came to the 13 colonies from many different regions, there were many who came from what is now Germany, as well as coming from Britain. The printing of Magna Carta and knowledge of the clauses of this document was seen as something that could bring people together to teach everyone their rights, regardless of where they had come from. So there's numerous examples of prominent American thinkers praising Magna Carta and the ideas of Sir Edward Coke. Thomas Jefferson wrote to James Madison that a sounder Whig never wrote, nor profounder learning in the orthodox doctrines of the British Constitution, or what were called English liberties. And as the 13 colonies felt they were having taxation without representation increasingly imposed on them, the idea that Magna Carta freed them from arbitrary taxation became very important to the philosophical groundings of the American Revolution. So there are many American thinkers who argued that the British, in a sense, had lost their way and had moved away from treating Magna Carta in the literal sense. There have been too many new statutes that had superseded the ideas of the 13th century Magna Carta. Now, of course, the Americans did not fight the British alone. The theme that's come up again and again in this lecture, war with France, happens in the American Revolution as well. King Louis XVI saw an opportunity to destabilize the British Empire. He sends French troops under Lafayette to fight for the Americans, and so they learn all about Magna Carta and this American and British political culture, and they bring those ideas back to France, where Louis XVI found himself bankrupt, having invested so much in the American Revolution. Louis XVI calls the Estates Generales in 1789, trying to find an answer to his financial problems, and instead he finds himself in the midst of a debate over how France should be governed. Much against his will, he initially becomes a constitutional monarch until he attempts to flee France with his family in 1791, repudiates the revolution, and is ultimately overthrown. And Louis XVI and his queen, Marie Antoinette, are both beheaded during the Terror. But before the guillotine comes out and the heads start rolling and that famous period of the French Revolution begins, we have these early months where the French Revolution was seen as an opportunity for political reform, and it excited reformers all over Europe. The idea that this newly founded National Assembly could simply remake what had been a very traditional monarchical society. The most famous of the documents that are issued by the National Assembly in 1789 is the Declaration of the Rights of Man and the Citizen, that no person shall be accused, arrested, or imprisoned except in the cases and according to the forms prescribed by law. Anyone soliciting, transmitting, executing, or causing to be executed any arbitrary order shall be punished, but any citizen summoned or arrested in virtue of the law shall submit without delay, as resistance constitutes an offense. So we can see the seeds of how this could develop into Robespierre's Terror, but a lot of the Declaration of the Rights of Man emphasized there were to be legal rights for people of all backgrounds. The National Assembly debates religious minorities and agrees that they too should be allowed to serve in the National Assembly. Racial minorities as well, as delegates begin arriving from Guadeloupe and Martinique and what is now Haiti, that has its own revolution. In 1801, the National Assembly stops being progressive when women express an interest in being involved in this political change. That's too revolutionary for the French Revolution, and so women are not allowed to serve in the National Assembly, and it's treated as a male space. But there are many who object to this, and the playwright Olympe de Gouges writes the Declaration of the Rights of Woman and the Female Citizen. Mary Wollstonecraft is also writing the Vindication of the Rights of Woman at this time. So we see the French Revolution is treated as an opportunity for wider political reform on a wider scale. Now, Canada has a very different history than either the United States or France. We don't have that violent revolution, and we not only inherit the English common law system, but the constitutional monarchy, so we have a political and a legal connection to that series of documents that begun with Magna Carta, the 6 statutes, the Petition of Right, the Bill of Rights. The British North America Act of 1867 makes clear that Confederation was to happen along the lines of the state that existed in Britain, and that state at that time was repealing some of the clauses of Magna Carta. Statute reform was taking place. Lawyers were going through these older medieval law codes and removing clauses that no longer seemed relevant in a Victorian post-industrial society. And that was extremely controversial, that historic charters like Magna Carta were being gradually removed from the statute books. But the result was that eventually only freedom of the church, freedom of the City of London, and that justice shall not be delayed or denied remained on the statute books. So Canada's coming of age in Confederation at a time when statute reform was taking place. So whereas Magna Carta is treated very literally in an American context, in a Canadian context it's often viewed more symbolically as this historic document that symbolizes democracy, law, and human rights. And it's been cited in hundreds of Canadian court cases, but it's been made clear that Magna Carta the legal case in Canada can't stand on Magna Carta on its own, that it's a statute amenable to parliamentary legislation. This reflects the climate of the 19th century, which is quite different from the climate of the 18th century. Nevertheless, when we look at Canada's Charter of Rights and Freedoms, we see remarkable similarities to Magna Carta. Everyone has the right to life, liberty, and the security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Everyone has the right not to be arbitrarily detained or imprisoned. Any person charged with an offense has the right to be informed without unreasonable delay of the specific offense and to be tried within a reasonable time. So 800 years later, the idea that justice shall not be delayed or denied continues to have a profound impact in Canada. Now, I've been talking a lot about politics and law over the course of this lecture, but it's important to note that Magna Carta also has a profound impact on popular culture. This is one of the few times I get to talk about Rudyard Kipling and Jay-Z on the same slide, but both of them were inspired by Magna Carta in different ways. The excerpt from the poem that I have here, What Say the Reeds at Runnymede, was written by Rudyard Kipling for the 700th anniversary of Magna Carta, and it reflects how we see Magna Carta in modern times. At Runnymede, your rights were won at Runnymede. No free man shall be fined or bound or dispossessed of freehold ground, except by lawful judgment found and passed upon him by his peers. Forget not, after all these years, the charter signed at Runnymede. And then on the slide as well is the cover art from Jay-Z's album, Magna Carta, Holy Grail, that was displayed in an exhibition at Salisbury Cathedral along with one of the original versions of Magna Carta. So whereas sometimes this popular culture legacy is treated as being entirely separate from the political and legal legacy, that particular exhibition made clear that all of these different popular culture manifestations of Magna Carta and of villainous King John have kept the document in the popular consciousness with a very wide audience. I've also been talking a lot about the Atlantic world, Britain, France, Canada, the United States, but the 20th century has seen Magna Carta go global and engage with traditions and cultural traditions in a wide range of areas of the world. The United Nations Universal Declaration of Human Rights, for instance, is informed by Magna Carta, as it's informed by a number of other global cultural traditions. And we see all sorts of examples of Magna Carta being significant in a global context in the 20th century. I have here an excerpt from Nelson Mandela's speech at Rivonia in 1964. Before he was a freedom fighter, he was a lawyer at the firm of Mandela and Tambo, and he'd been educated in the British tradition, as Afrikaner universities in South Africa did not accept African students, so he'd been educated in the British common law tradition. And this comes out in his speech at his trial. The Magna Carta, the Petition of Rights, and the Bill of Rights are documents which are held in veneration by Democrats throughout the world. I have great respect for British political institutions and for the country's system of justice. I regard the British Parliament as the most democratic institution in the world, and the independence and impartiality of its judiciary never fail to arouse my admiration. Now, Mandela then spends 27 years imprisoned on Robben Island, but when he was released and became president of South Africa, one of his priorities was ensuring an independent judiciary. So Magna Carta clearly had an impact on his legal and political thinking. So 800 years later, Magna Carta is still exerting a powerful political, legal, and cultural influence. The image here is of the 4 surviving versions of the document that exist from 1215 that were all displayed together at the British Library this year. And the Director of Operations and Services of the British Library explained Magna Carta is a fundamental document in the history of our nation and has international significance for the definition of the rights of the individual. The declaration that no free man shall be imprisoned without the lawful judgment of his equals still has great resonance 800 years after Magna Carta was first drawn up. The 2 original copies of Magna Carta are among the British Library's most historically evocative, precious, and popular treasures. So I encourage you all to visit the Alberta legislature to see the 1300 Magna Carta that's on display there until December the 29th. So I'm going to leave it here so that there's some time for questions. This is my book, Magna Carta and Its Gifts to Canada. There are books for sale at the back, and I would be glad to sign books after the lecture. And for all of my writing on history and royalty, I encourage you to visit my website, royalhistorian.com. Thank you very much for listening to this for 800 years of Magna Carta. Thank you.